Can I just say something about Andrea?
Guys, we seem to be getting near the end of the state's case against Jim Martin. In trial time, they are just starting day 3, and we are going to be hearing from Detective Tara Evans. We already know that Detective Evans is who spoke with Christy at the hospital and who recorded the statements that Christy, by her testimony, doesn't recall giving. And we've heard a little bit about circumstances under which those statements were obtained that suggest Christy may not have been in the best state of mind. She was still in the hospital, like kind of barely in the hospital, at least at some point, receiving medical treatment, having tubes put in, had been administered morphine. And so we'll have an opportunity now to hear Detective Evans's account of why did she choose to interview Christy under these circumstances, and what did she see? What was she able to pick up in terms of Christy's ability to kind of track the conversation and give meaningful answers and so forth. But we have wrapped up with, it seems, we have wrapped up with the forensic case. We heard from the analysts in the last video. A lot of Jim's blood everywhere. They didn't test so many of the areas that would have had Christy's, at least where we would expect there to be a lot of Christy's blood, like in the bedroom. But her blood was found mixed with Jim's on the BlackBerry device, as well as on the handle of the firearm. And we learned that two spent shell casings, which were recovered, both matched that pink 9mm handgun. I hate the matching, I really do, but that's the testimony. That's what they were allowed to say. It's not scientifically very strong, but is what it is. But still no real explanation for where did the second bullet go? When did the gun get fired? Didn't find it in the house, anything like that. So Detective Evans, as presumably the chief investigator of the case, is kind of also presumably the one who should be expected to anticipate and account for potential weaknesses in the case. So I am expecting, either on direct or certainly on cross, if they don't deal with it on direct, some potential challenge about what'd you make of this second shell casing, and any efforts to be able to locate a second bullet associated with it. So let's turn to Tara Evans and see what her evidence is going to show us.
And she remains under oath. Give us your name and then spell your first and last name for the jury.
Tara Evans, spelled Taraevans.
You may inquire.
Thank you. Good morning.
Good morning.
Yesterday, very briefly, you testified that you were the primary or lead detective in the investigation of James Martin on an incident which is alleged to have occurred November 23rd of 2010.
Yes.
Okay. Would you tell the jury what's the job of a primary detective or a lead detective in an investigation such as this?
As a lead detective, in a case like this, we obtain all the preliminary investigation from the road patrol at first, which would be written statements or verbal statements that maybe would have been given to them when they arrived on scene. I do follow-up interviews in regards to those statements that were received either by the victim, witness, or the suspect at that time, if it's feasible. I respond to the scene. At the scene, I make the determination if forensics personnel is needed to document the scene and to take anything into evidence. I also, during the investigation, I myself do follow-up leads during interviews. If any information is provided, I follow up on those leads to collect all evidence necessary for the case. In doing so, I at times need to obtain search warrants or arrest warrants depending on each case. And at the end of the investigation, I gather all the information, type up reports, and provide all evidence and all the information I gathered to the state attorney's office for them to prepare.
So is it fair to say as a lead detective, you're basically almost like the quarterback of the team in deciding what's going to be sought and directing personnel to do follow-up or doing some of that yourself?
Yes.
And do you work with various personnel?
Is that the quarterback or is that the head coach? It's the problem with leading with your analogy. She didn't choose that analogy. He chose that analogy. The quarterback? Maybe. Sounds like more of a head coach kind of thing for me. You're making the calls about who's on the bench, who's playing, what kind of play are you going to pursue. Those aren't quarterback calls. Quarterback just decides, if I got an option play, what option am I going to run? A little more limited. That seems a little bit more like the shift commander or something.
Of both your agency and other agencies in the investigation of cases such as this.
Yes.
And what I'd like to do is I'd like to talk to you, but I'd like to talk to you about the work that you did in this case.
Okay.
Did you first become involved in this case the night of the incident, November 23rd, 2010?
Yes, I did.
And were you called out
Yes.
to the scene?
Yes, I was.
Okay. Will you tell the jury what did you first do in regards to this case?
I received a call from the detective that was on scene at the hospital with the victim. I responded to the hospital initially, and at that time made contact with the deputy and obtained the information she had gotten at that point.
Let me ask you, do you recall approximately what time you arrived at Florida Hospital, Apopka?
I know my interview began approximately 8:15 p.m. So I would have had to arrive at least maybe approximately about 8, give or take.
You said that your interview started at approximately 8:15. Who was that an interview with?
That was with Christy Martin.
And where did you speak with Ms. Martin?
Inside the emergency room while she was being treated.
And tell us about what all was going on in that room while you were interviewing Ms. Martin.
Medical personnel, doctors and nurses were going in and out. They were checking on statuses. Actually, the interview was interrupted a couple of times for x-rays and other medical necessary critical procedures that they had to do to sustain her stability. So there was a lot going on. Just a lot of people coming in and out during the interview, and then just the interruptions for her to be taken for those procedures.
And did you have an opportunity to speak with Ms. Martin face-to-face in the same room?
Yes, I did.
Would you tell the jury how Ms. Martin appeared how was her physical appearance during the interview?
I mean, looking at her, I could tell she was in a lot of pain.
And what did you see about her exactly to lead you to believe that she was in pain at the time that you were attempting to talk with her?
Well, for one, obviously, physically, I saw that she had blood like around her ears and her hair. I did see her left leg was bandaged up. It was a very large bandage, maybe approximately 8-9 inches in length on her left calf. It was just very difficult to speak to her at that time just because of the pain that she was in. I could just tell that she was having a difficult time gathering information, for me to gather information, because it was hard to understand her given her state at that point.
And were you able to easily hear and understand Ms. Martin while you were asking her those questions in the emergency department of Florida Hospital, Apopka?
At times it was difficult to hear what she was saying given just the state that she was in. It was difficult for her to speak. She had an oxygen mask on, which obviously made it a little bit more difficult.
But besides the oxygen mask, was just the way she physically appeared and physically acted, Was it difficult to have a real dialogue back and forth with her?
Yes, actually, a couple of times when I'd ask a question, she would pause, she wouldn't answer. I could tell that, she was having a difficult time speaking. So it wasn't a normal conversation you would have during an interview. So I could tell she was in a lot of pain as far as trying to answer the questions I was asking. And I even told her at times, just take your time and answer when you can.
And why was it so necessary for you to ask these questions of Ms. Martin while she was in this, state of trauma still?
It's important, one, because we need to know what happened. We need to find out, who did this to her, what happened in the incident, where did it occur. But at that time, that's what was so critical. Find out what happened and who did this to her so we could start an investigation.
And I'm sorry, go ahead.
Because we didn't know what her state was going to be. She was in very critical condition.
Well, and what I want to do is, did you have an opportunity to speak with Ms. Martin again the next day?
Yes, I did.
Okay, I want to leave the 23rd for a minute and let's just go to that interview so that we can, finish this portion. When did you speak with Christine Martin the following day?
I'm not exactly sure the time.
That's fine. Where was she?
She was at Orlando Regional Medical Center.
And was she still admitted to the hospital receiving treatment?
Yes, she was.
And during your interview with Ms. Martin, was she receiving medication?
Yes, she was.
And from your, and I don't know if I asked you yesterday, but what is your, how long have you been a sworn law enforcement officer for?
Since 2005, so almost 7 years.
And given in that 7 years, have you come across persons that were under the influence of medications or other substances?
Yes.
And during your interview with Ms. Martin the following day at Orlando Regional Medical Center, did she appear at times to be under the influence of medication or substances?
Oh, yes, she did.
And why, tell us about that interview and what led you to believe that.
At the beginning of the interview, she was actually pretty alert. She was in a lot better stable condition. She was alert. She was able to speak. The nurse kind of came in and out a couple of times during the interview. And I noticed towards the end of the interview, she began to close her eyes a little bit more, kind of slowly doze off. I had to call her attention a few times at the end of the interview. So at that point, I decided it's probably best just to end the interview at that point.
Okay.
She is being really rehabilitative of Christy, isn't she? Really helpful. Really helpful. Yeah, I mean, more helpful certainly than the doctors. She seemed drugged, under the influence. She was in a ton of pain. She had a hard time holding a regular conversation. She had to pause, couldn't answer. Wasn't like a normal back and forth type of conversation. Only did it because they had to be able to start the investigation, but her condition was so critical, they didn't know. They didn't know if, what state she would be in. She's kind of saying they didn't know if she's like gonna die or something. Maybe a little bit of an exaggeration in light of what we heard from the doctor, but she had been shot in the chest, lost blood, etc. So from the detective standpoint, perhaps not entirely unreasonable, although you would think the doctor would say, she's stable, or, prognosis is good or whatever, but maybe not. Certainly she's not related to Christy or anything like that, entitled to that type of information. But it's just, you can definitely tell, you can definitely tell when the detective is talking about an interview with a victim versus an interview with a perpetrator, just based on the accommodation, the lenience, the understanding that is given. She's really showing a lot of that to Christy here. We had that hint that Jim gave a statement to somebody. Seems likely it would be her, the detective, because we know Jim said something about taking a shower inside that neighbor's house on the 30th when he was ultimately arrested. So I suspect it's her, and I'll be very interested to see what sort of accommodation, understanding, whatever, does Jim get?
Now let's go back to the day before.
Okay.
You told us about going to Florida Hospital, Apopka, speaking to Ms. Martin. After you spoke with her, what did you do next?
I know I did speak with the witness that drove her to the hospital, which would be Rick Cole.
And after speaking with Mr. Cole, did you remain at the hospital?
I remained at the hospital while the forensics personnel, Alina Burrows, was collecting her items and processing the vehicle that she was brought in. So I stayed there at that point.
And is that the red Isuzu that was in the emergency bay?
Yes.
After that, did you have occasion to go to Fox Tree Trail?
Yes. After she completed what she needed at the hospital, we both responded to Fox Tree Trail to where the incident had occurred.
Okay, and let's talk about that. What did you do at Fox Tree Trail that night?
I walked in actually with Alina. I let her go ahead so she could document the scene, and she was speaking to me of the blood trail that she had seen outside the residence.
And was that pointed out to you by Ms. Burrows?
Yes.
And did you also observe that?
Yes, I did.
Did you have an opportunity to go inside the Martin home at 1203 Fox Tree Trail?
Yes, I did.
And did you go through the entire house?
Yes, I did.
And why did you do that?
For myself to document any evidence that I could collect myself, not as far as physically collecting, but to observe what could have occurred in the residence. Was there a struggle? Was there anything else that could have happened inside the residence? Was there anything missing? Just to make a note how the condition of the residence was at that time.
Now, at this point, when you enter inside the home, are you still trying to determine what might have happened?
Correct. I did have information that the victim had given me, but I was still in the process of conducting an investigation.
And at that point, are you still conducting an independent investigation to determine the incident, possible suspects, what might have happened, or do you just take the victim's interview at this point and that's it?
No, obviously I did get her a portion of her side of the story at the hospital, but when you go to the scene, you look and you try to gather information from the scene to see if it corroborates with what was given, and to also provide additional leads if possible.
Your Honor, may I approach the witness?
You may.
Detective, I'm approaching with two photographs that have been marked for identification purposes as State's Exhibits AO
More
and
photos.
AP. AO, AP, please don't show those to the jury yet.
Sorry.
But I'll ask you to review those two photographs. Do you recognize the contents of those two photographs?
Yes, I do.
And do you recognize those to be photographs from the bedroom, the master bedroom of the house at 1203 Fox Street?
Yes, I do.
And do those pictures fairly and accurately depict the items that are within there as seen by you on November 23rd, 2010 during your walkthrough of the home?
Yes, I do.
Your Honor, at this time, the state of Florida would seek introduction of states AO and AP into evidence. No objection.
Be received without objection, Madam Clerk.
Numbers 89 and 89 and 90.
And after those are marked, Your Honor, I'd ask for permission to publish on the projector.
You may.
Thank you.
Got to warm it up. First time today.
I'm going to first show you an accepted in evidence and published on the display as State's Exhibit 90. And specifically, in the bedroom,
Record player, watch, blood on the watch.
Detective Evans, did you observe numerous items of jewelry?
Some blue
Yes.
pills there.
Now, why, or what would be the significance of finding an incident inside of a home and seeing in plain view jewelry all over the place? What sort of investigative significance would that have?
With jewelry and other personal expensive items still being in the home, it leads me to believe that there was no burglary or incident of that nature that would have occurred at the home.
And showing State's 89 in evidence, the photograph of the dresser. Besides those two rings in the diamond watch we saw in 90, were there multiple items of jewelry strewn throughout the dresser area, including watches, rings, diamonds, things like that?
Yes.
Thought we already had pictures of jewelry, but okay, it's fine. We'll have more. Why not? Why not?
Now, after going through the scene at 1203 Fox Tree, did you do anything else? The initial night, would you describe to the jury, what did Fox Tree Trail look like as it related to law enforcement presence?
There were a lot of, well, by the time I got there weren't as many probably, but there were a lot of patrol vehicles outside. When I initially received the call, I had asked that the scene be secured, so there was tape up there. The scene was secured at that point.
I mean, did this look like a crime scene on Fox Tree Trail in Apopka?
Yes, it did.
Number of police cars around.
Yes, multiple people.
Now, what did you do after, or did you do anything else after going to the 1203 Fox Tree house that evening?
Based on the information that was given to me at the hospital and the information that I observed at the scene, at that point, I went ahead and since the suspect was nowhere to be found, I went ahead and obtained an arrest warrant.
Does that mean as of the night of November 23rd, 2010, you were attempting to find the defendant, or to find James Martin in this case?
That's correct.
And do you see James Martin in the courtroom?
Yes, I do.
Would you please point to him and describe an article of clothing that he's wearing?
He's sitting at that table and he has a gray shirt with a black jacket.
Your Honor, may the record reflect the identification of the defendant.
Record will so indicate.
And at any point on November 23rd, 2010, did you personally ever see the defendant in this case?
On what date, I'm sorry?
November 23rd.
No, I didn't.
Never saw him on November 23rd. Determined, however, that she had probable cause to be able to arrest him. And so we have to, I think, take it then that whatever she saw at the scene, she thought at least generally corroborated the version of events that Christy had given her. Presumably, her affidavit for her arrest warrant is going to rely substantially on the version of events that Christy gave. And so this is potentially, one of the reasons why the defense is maybe upset about it, because if it wasn't really that good or that reliable, then you know it's a little bit of kind of having your cake and eat it too. It's like it's good enough to come in and arrest and charge him. I mean, you're saying you have probable cause to believe he committed a crime, but now also you're coming into court and saying, well, you know, it wasn't really, she was drugged, and wasn't real easy to have a conversation and stuff like that. Kind of trying to, I don't want to say make excuses, but just you know, give her lots of benefit of the doubt, anticipating that maybe she might not have been totally right about everything. But bottom line, if Jim's not there and she's got a crime scene that at least generally corroborates what Christy told her, then that's what she has to work with. So yeah, went straight to it the same night. Went to get an arrest warrant. Of course, didn't find him right away.
Now, in a moment, we're going to speak about your involvement and your actions on a week later on November 30th. But I want to ask you, between the 23rd, the night of the 23rd, and the 30th, when the defendant is found, were you conducting follow-up investigation with this case?
Yes, I was.
Now let's go to November 30th, 2010.
No specification.
Were you made aware of the fact that the defendant was apprehended in the neighborhood?
Yes, I was.
And what did you do after being notified of this apprehension?
He was apprehended in the neighborhood. This was a problem that we had from some of the last testimony, because they told us it was 849 Thompson Road, but we don't have a map, and the only person they asked, like, where is that in relation to the Fox Tree Trail, 1203 Fox Tree Trail, didn't know. It was one of the, I think it was the other crime scene investigator, the one who came in, like, took photos of the shed and things like that. The second shed, not the first shed. And she didn't know where Fox Tree Trail was. So we still don't have a good framework for where are these things in relation to each other. So we're getting closer here with it in the neighborhood, but it would be so helpful is to give us something. Is it a mile away? Is it a block away? What are we looking at here? I mean, no, she wasn't there. She wasn't there personally, but it is her job as the detective to kind of reconstruct based on what you do know and in the information you do get, what the movements would have been and stuff. So I don't know. We'll see if we get any clarity on that.
When I was notified, I was informed that he was being transported to Orlando Regional Medical Center to receive medical treatment. So I responded to the hospital so I can make contact with him to conduct an interview.
Detective, how long have you been in hospital?
Approximately 7 years.
Can you speak now?
Oh, yes.
Lean back and just speak.
Okay.
Use your outside voice.
May I proceed, Judge?
Yes, sir.
It's Detective. With that outside voice, I want to talk to you about what happened at the hospital that afternoon with you and the defendant. Did you have an opportunity to speak to the defendant at Orlando Regional Medical Center on November 30th of 2010?
Yes, I did.
Mm-hmm.
Why did you speak with him?
Well, I wanted to obtain his side of the story, basically. Find out what information he could provide me in regards to the incident.
And did you ask the defendant if he'd be willing to speak with you?
Yes, I did.
And did the defendant speak with you on November 30th, 2010 at the hospital?
Yes, he did.
And did you inform the defendant of his, we call them Miranda rights, but his constitutional rights?
That's correct, I did.
And every right that you informed him of, did the defendant acknowledge that he understood the rights that were being given to him?
Yes, he did.
And after fully giving the defendant his constitutional rights, did he agree to waive those rights to remain silent? And did he speak with you?
Yes, he did.
And during the interview, at any time during the interview, did the defendant communicate to you that he no longer wanted to speak with you?
No, he did not.
During your interview of the defendant, did you ever utilize any threats or promises that if the defendant spoke, then something favorable would happen to him?
No, I did not.
Did you use any, besides verbal threats, did you ever display a weapon, a baton, an asp, a taser, a firearm, anything to get the defendant to make a statement?
No, I did not.
And did the defendant freely and voluntarily speak with you at the hospital that afternoon?
Yes, he did.
Was this interview recorded?
Yes, it was.
And was it transcribed?
Let's hear
Yes,
it.
was.
Now, approximately how long did this interview go on for?
Well, the first section of the interview, I believe it was about an hour and a half. We got interrupted for medical proceedings. Then the second portion was almost 2.5 hours, so
Wow.
3 to 4 hours roughly.
And do you recall all 4 hours of that interview today? Every question you asked and every answer that the defendant provided?
No, not by memory now.
And would utilizing and reviewing the transcript that was made of that recorded interview help refresh your memory as to the specific questions and specific answers which were asked?
Yes, it was.
Your Honor, I would ask permission of the witness to utilize her copy of the defendant's transcripts for the following testimony.
Mr. Hancock?
Judge, I think with the proper predicate for refreshing our recollection, I would have no objection to that.
All right, sir. Mr. Vesio?
May we approach for a moment?
Yes, sir.
May I proceed?
Yes.
During your interview of the defendant, did you discuss with him where he was hiding for the 7 days between the day of the incident and the day that he was found?
That's loaded.
Yes, I did.
And do you recall where the defendant told you that he remained in hiding for that week?
Yes.
Okay, and where did the defendant say he hid for that week?
In a shed that was located behind the resident of Scott Selkirk.
And is that the house at 1223 Fox Tree Trail?
Yes, it is.
And what was the relationship between the Martin house and the Selkirk house? How far away were they?
I think it's 12:06, but anyway.
Not very far. I mean, you're looking at two houses on the opposite side of the roadway.
So he said he was hiding in Scott
And did the
Selkirk's shed.
defendant tell
7
you how
days.
long he had remained in that shed for?
He believed he was in there for 7 days.
Did you ask the defendant what he did for those 7 days?
Yes.
And do you remember what the defendant answered in response to your question, what did you do for 7 days?
Yes.
Okay, and what did the defendant say he did for those 7 days?
He said that he had passed out. He was laying there. He, at one point, was able to crawl to the residence to obtain some food. But mainly he just laid there and waited for someone to find him.
Poor guy. Doesn't that just sound like such
Did
a
you ask the
terrible-
defendant during your interview whether or not he ate any food or had any drinks during that 7-day period?
Yes, I did.
And do you recall what the defendant answered?
Word for word, no, but yeah.
Would looking at the transcript of the interview refresh your recollection as to what the defendant answered?
Yes.
May I approach the witness, Judge?
Yes, sir.
Going to make him go through the formalities of refreshing instead of letting her just read the transcript and testify to it. That was what Mr. Hancock wanted during that sidebar with his objection, and he got it. Jim made a scared
Do you have
little.
a copy of the transcript with you?
Yes, I did.
Okay, would you go ahead and take that out?
Scared little glance over at the jury with that lying there, crawling for food, etc. Like, are they buying this?
And I direct your attention to the first part of your interview, page 20, starting at around line 13. with the question, how did you eat and drink? If you would review lines 13 through line 22.
So we had a long conversation about how did he eat and drink.
Okay.
Is your memory now refreshed?
Yes.
Okay, let me ask you again. What did the defendant say he ate or drank during those 7 days?
He had a roll and a drink.
And did the defendant say where he got that roll from?
Yes, Scotty's house.
A lot of lines to say a roll and a drink.
During your interview of the defendant, did you discuss whether or not he had any medical conditions?
Yes, I did.
And what did the defendant tell you? Did the defendant tell you that he suffered from any specific medical conditions?
He was diabetic and had high blood pressure.
Did you ask the defendant if he took any prescribed medications regularly?
Yes, I did.
And what was his response to that?
I know he said he took multiple pills daily for the blood pressure and for the diabetes.
Do you recall specifically how many pills he told you he took every morning and every night?
No, I do not.
We're looking at your transcript, refresh your memory to that. Direct you to page 23, lines 17 and 18.
But did he take insulin? Did he take insulin for his diabetes? Maybe not, if it's not the right type.
How many pills did the defendant tell you he took every morning and every night?
In the morning, he took 8 to 9 pills, and at night, he took 6 to 7 pills.
And did you ask the defendant during the 7 days that he was gone if he took any of his medications?
Yes, I did.
And what was his answer?
No, he did not.
Did you ask the defendant, due to his diabetic condition, what would happen to him personally if he didn't eat?
Yes, I did.
And what was his response to you, how he would respond to not eating?
He would lose his strength. I don't remember the exact words, but he wouldn't have any strength.
Okay. I mean, yes, I buy that, but only in a
Now, during your
really
interview of the
general
defendant,
sense.
did you have an opportunity to talk to him about the relationship that he had with Christy Martin?
Yes, I did.
Now, did you, or did the defendant talk about, in the 20 years that they were together, how often they would be together or apart?
Yes, he did.
And what did the defendant tell you, or what did the defendant tell you about how often that him and Ms. Martin were apart in their 20-year relationship prior to the week before this incident?
He had informed me that within the 20 years, they were together 24/7, and they had spent only 2 nights apart from each other within 20 years.
Well, we know they spent more than that apart just in the week leading up to the shooting. But oh God, honestly, that sounds miserable to me. That sounds miserable. Like how codependent. This is just awful. It just sounds terrible to me. I mean, everybody is wants companionship, and it's a wonderful thing, especially if the person that you're in the relationship is somebody that you like. You actually like spending time with them. The problem is that at least from Christy's version, that wasn't them. That wasn't them from the very beginning. He didn't like her, didn't respect her, didn't treat her well. And she thought he was a misogynist. She thought he had some views she didn't share and didn't seem to appreciate either. And just arguing all the time. She described she just got tired of arguing. You know, she had that exhaustion when she described what it was like trying to be heard with Jim. So this is not a married to your best friend together all the time type of situation. It just sounds like torture. Sounds like control. Sounds like dependence. It really does. just excruciating to me. But in any event, not even really accurate because just the week before they had spent more than that number of nights apart.
During your interview of the defendant, did you speak with him about the incident itself and what caused and led up to the incident?
Yes, I did.
And did you speak, during your conversations with the defendant, did you ask him about, or did the topic of sharing come up?
Yes, it did.
And would you tell the jury how the subject of Sherry came up during the interview?
How it came up?
Yes, ma'am. Do you need me to ask it? Does that question make sense?
Yeah.
Okay, let
I'm
me
not,
ask.
okay.
Did you ask who first spoke about Sherry during the interview? Was it you or the defendant?
That I don't recall. I'd have to refer to the transcript.
Okay, and would referring to the transcript refresh your memory?
Yes, it would.
Okay. Direct you to page 52. Beginning at line 4.
I'm betting the detective
And going
brought
through
Sherry
line
up first.
13.
Detective did, huh? He didn't volunteer Sherry. Really, really scoping out that jury now. Throwing out a line. Save me.
Who brought
Save
up
me,
the
jury.
topic of Sherry first in the interview?
James brought it up.
Oh,
in
he
the
did.
interview.
Okay.
And did the defendant share with you a discussion that he had with Christy Martin about Christy going to see Sherry?
Yes.
And did the defendant tell you his thoughts on that and how he responded to Christy's statement that she was going to see Sherry?
Yes.
Do you recall specifically the words that the defendant used?
No, I do not.
And would looking at that transcript refresh your memory?
Yes, it would.
Okay. I direct your attention to page 52, lines 15 through 19.
Breaks up the flow a little bit, doesn't it? Having to do it this way. That's why the defense wants to do it this way. Jim brought her up first. That's good. It would be way worse
And,
if he hadn't.
what did the defendant specifically say in response to Christy going to see Sherry?
Word for word.
Please.
Can I read from?
Well, after refreshing is your memory now refreshed as to the exact words from those 5 lines?
Can you memorize 5 lines? This detective is a little slow, isn't she? How long
You
did
can
it take you
He
to read
said,
5 lines?
Why,
Speak up, please.
why, honey? I don't think that's fair. Why are you going to, that's an old girlfriend of yours. I don't think that's fair.
Did the defendant ask to be able to travel with them?
Yes, he did.
Did the defendant say why he left the house that Tuesday or during this conversation about Sherry Lutz?
Yes, he did.
And why did the defendant say he left the house after this first conversation concerning Sherry?
He didn't want to be there to see her leave.
Did the defendant, during his interview, talk about whether Christy going to see Sherry broke his heart, how it made him feel? Did he talk about that a few times in the interview?
Yes, he did.
And what was his responses?
That he was hurt. That was his main response, is he was hurt. He was just hurt.
I want to fast forward to the day before the incident, which would have been Monday. Did you discuss with the defendant what occurred Monday in relation to Daytona Beach?
Yes, I did.
And did the defendant admit to you traveling to Daytona the day before this incident in order to follow Christy Martin?
Yes, he did.
The man stalking her.
Would you tell the defendant or would you tell the jury, excuse me, what the defendant said to you he did in regards to traveling to Daytona Beach the day before?
He left his house. He drove to Daytona using I-4. Right before getting to Daytona, he did turn around.
And why did he turn around?
In hopes to see if her vehicle was heading to Daytona.
And did the defendant ever admit to you making it all the way to Daytona?
Yes, he did.
And what road did the defendant tell you he ended up on in Daytona?
A1A.
Did the defendant during his interview with you tell you exactly where on A1A he went to?
Yes, he did.
And where did he go to?
He was parked right across the street from the Comfort Inn.
And did the defendant tell you what he saw at the Comfort Inn on A1A in Daytona the day before this attack?
Yes, he did.
And what did the defendant tell you he saw?
He observed Christy and Sherry walking towards the beach. And he also observed Christy's vehicle in the parking lot,
And what vehicle was that?
the yellow Corvette.
And did he admit to seeing the two of them, Sherry and Christy, together in Daytona the day before?
Yes, he did.
And how did the defendant describe to you how he felt about seeing Christy Martin and Sherry Lusk together in Daytona?
Yes, he did.
And how did he describe how he felt?
He was hurt.
He was hurt. He was hurt. I'll bet he was. I'll bet his little ego was very, very injured by that. He was hurt. Did you ask him about the phone calls and the stalking and the sending the revenge porn out? Was that because you were hurt, or was that because you were pissed? Because that's the point where you were ready to retaliate. She hurt you. Yeah, you were hurt. You were freaking injured because you'd lost control. Your possession decided she had a mind of her own and the ability to make her own choices. Hurt. He was hurt. Sure he was. Sure he was.
Did you ask the defendant about whether or not he had any conversations between himself and Christy Martin while in Daytona or right after seeing this in Daytona the day before?
Yes, I did.
And did the defendant admit to you to having conversations with Ms. Martin that day?
Yes, he did.
And would you tell the jury what those conversations were as told to you by the defendant?
I'd have to look at. I don't recall exactly.
Well, with looking at the transcript, refresh your memory as to what the substance of those conversations were.
Yes.
Okay, I'll direct you to page 75. Starting at, actually 74, starting at the last question, line 24, through page 75.
Where are they
line
zooming in on this guy?
11.
Is this a relative of Jim's or something? Also watching the jury. How are they taking this? I don't think they're probably taking it well, ma'am. I mean, she looks like Jim. That's got to be Jim's mom. Look at her. She looks just like him. Sister, maybe? For sure.
And then I'd also ask you to review page 79, starting at line 14 and going through line 23.
Did he admit threatening her that he was going to tell everyone, send out the revenge porn, and etc.? Did he admit to any of that? Did you confront him?
So I'll ask you again, what was as told to you by the defendant during your interview, what did he say to Ms. Martin the day before that Monday?
Initially, the conversation, he explained that Christy had called him. She had asked if he had called, and he said no. He, it must have misdialed or something, and that Christy said, I must have just missed you, and he said, yeah, I just missed you, all right.
And then at that point, did the defendant talk to you about text messages he started sending to the victim?
Correct. Later, after that conversation, Christy and him began texting back and forth. During the text, he had stated to Christy, it'd be real nice if these pictures get out.
Do you remember, were those the specific words that he used?
Specifically, I'd have to review it again.
Okay, then I'd ask you to review page 79, line 19.
Trying to
As to the
minimize
exact words that the defendant told you he texted
threat.
to the victim.
the
He stated,
blackmail.
Christy, it'll be real nice if these pictures hit the market.
Hit the market.
Now, did you have an opportunity to speak with the defendant about the day of the incident, Tuesday, November 23rd?
Yes, I did.
Now, did you and the defendant talk about what his thoughts were during the day leading up to when the incident happened?
Yes.
Did you ask the defendant whether or not anyone was over at his house prior to the attack that day?
Yes, I did.
And who did the defendant state was over at his house prior to the incident?
His neighbor, Scott Selkirk.
And what did the defendant tell you that he shared with Scott Selkirk?
Well, he explained the situation between Christy and Sherry and how he was upset about the relationship.
Do you recall the exact words that the defendant told you that he shared with Scott Selkirk earlier that day on Tuesday?
No, not the exact words.
Would reviewing your transcript refresh your memory?
Yes.
I direct you to page 81, lines 12, 13, and 14.
Somebody else over there looking over at the jury and not seeming real happy about what he sees. Keep praying, Jim. Maybe they'll just think you were hurt and therefore it's all okay. They really think that. He's like really thinking that. Maybe they'll appreciate how I'm the victim here.
And what were the words that the defendant told you during your interview that he shared on Tuesday with Scott Selkirk?
He said, I feel bad, Scotty. I don't know how I'm going to live without her. I don't know how.
We lose something here. We kind of froze up.
I don't know how I'm going to live without her. I don't know how.
Do you recall the last portion
No, I
of that? Go ahead and review again, line 13, starting with I really to line 14.
I really don't think I can live without her.
During your interview with the defendant, did he also acknowledge speaking to Bruce Brasher on Tuesday before the incident?
Yes, he did.
And did the defendant tell you that he had shared similar thoughts with Bruce Brasher?
Yes, he did.
Of course, we heard from Bruce. Heard from Bruce that he was offering to share share those videos, those photographs.
Your Honor,
Right.
one moment, please.
Yes, sir.
Thank you.
Bruce was Maria's husband. He was the contractor from Houston.
Now, during your conversations with the defendant, did you ever ask the defendant point blank if he had ever stabbed Christy Martin during the afternoon of November 23rd?
Yes, I did.
And what did the defendant tell you about whether he stabbed Ms. Martin?
He
He
denied it.
said he did not stab Christy.
Did you ask the
Denied it.
defendant
Of
that
course he
day,
did.
November 23rd, if he ever shot Ms. Martin?
Yes, I did.
And what was his answer to that?
He did not shoot her.
It doesn't matter what the evidence is, how caught red-handed they are. Domestic abusers will never freaking admit it, ever. They will always deny it. This is the whole, I forget the, the narcissist prayer. I didn't do it. And if I did, then, it's like the stair step. They just start making excuses for it as soon as they're trapped. But first step, always denial. The denial is through the freaking roof. Does he not? Does he not? Of course he knows. They know that Christy has been stabbed and shot. What, they're going to think it was just a coincidence? Somebody else came along and did it? And you're going to sit there now and try to argue self-defense. You didn't tell him that at the time, did you? Because that would have been, yeah, I did. I had to, because she was attacking me and I feared for my safety. Not what he said, is it? Nope, just nope, I didn't do it. The denial. Oh, my Lord, the denial is just stratospheric with these people. I swear. Had to go check my notes for Bruce Brasher. Yeah. He said he was sitting at the breakfast table. She'd left him for another woman. And he was sitting at the breakfast table. He had 2 loaded guns. We heard about 2 guns. He had 2 loaded guns. Was afraid that Jim might commit suicide, but he never actually said he would do that. He told Jim to fly to Houston and that he would pay for it. And Jim declined. Instead, he said he had some pictures of Christy that he described as sexually explicit and said he'd send them. And Bruce told him, I don't want to see them. Don't want to see them. And it was an off enough conversation that he called the police about it. That's how Bruce Brasher remembers that conversation that Jim describes as, I don't think I can live without her. He's just so sad and victimized by Christy. Won't anybody understand his pain? No. No, had you not shot her and stabbed her, I might feel bad for you. But you shot her and stabbed her. So my sympathy level is down somewhere in the depths of the Mariana Trench. You shot and stabbed her and then acted like nobody was going to figure that out. And it's just, the thought process, I don't have good theory of mind for abusers. I really don't. I just can't put myself into this mindset of why would you, they already know, dude. They already know. What do you think they're going to think? They're just going to be like, oh, he said he didn't. Well, I guess everything's okay. Or is it just you're going to fight them every single step of the way? Deny and then defend and then excuse and then project and all of that. Didn't stab her, didn't shoot her. I don't know who stabbed and shot her. Must have been some burglar. Oh, I don't know. Wonder what, how hard did she push? How hard did the detective push? So you didn't do it. So how did Christy end up stabbed and shot after she left you that afternoon? How did she end up at the hospital stabbed and shot? Still looking at the jury.
Did the defendant ever tell you if he had the opportunity to kill Ms. Martin that day?
Yes, he did.
And do you remember
Coulda
what the
killed her
defendant
when?
said about his ability to have killed her that day?
Yes, I do.
And what were the words that he used with you during that interview?
I don't recall the exact words.
Would looking at the transcript refresh your recollection?
Yes.
I would direct you to the second transcript of your interview, the second part, page 76.
They want these words verbatim. And the
Lines
thing,
5, 6, and 7.
the thing about this is that the jury is seeing her reading this, and so they know. They know these are the actual words in the transcript. What did he say? He could have shot her when? Could have killed her, could have strangled her, and she would, what? Shut up. Don't talk to me. So I want to hear your worried noises. Yes, the jury is hearing all of this, and no, they're not buying a word of it.
And what did the defendant tell you about his abilities to have killed Ms. Martin that day?
You asked me if I tried to shoot Christy? No. You asked me if I tried to kill Christy? No. Did I shoot Christy? No. Could I have killed Christy? Yeah, the gun was laying right there.
Where? Did he say that the gun was laying?
I'd have to look again.
You can do so.
Could I have killed her? Yeah, the gun
Yes,
was
he
right
said
there.
beside her.
So the fact that she ended up shot, what, did she shoot herself, Jim? Is that your story?
Yes, sir.
She shot herself so she could blame you? Is that your story? That ain't self-defense, is it?
I have no other questions of the witness.
All right, sir, you may cross.
Thank you.
Got about halfway through, and the rest is cross. This is going to be a long cross.
Detective, did you request blood samples to be taken or blood or swabs to be taken from the blood on the floor in the master bedroom?
I'm sorry, what was, did I request what?
That swabs of blood or blood samples be taken from the floor of the master bedroom?
For Alina Burrows to take
Yes.
those? I did not specifically request that.
Did you request samples of blood be taken from the chest of drawers that were at the end of the bed?
Not that I recall.
Did you ask for samples of blood to be taken from on the dresser or on the jewelry as we saw in that one photograph?
Not that I recall.
So none of the blood in that master bedroom was sent for analysis or testing?
Not that I recall.
Was yes or no? Did any go?
I don't recall. I don't know if she submitted anything or not on that.
You didn't request it though as the lead detective.
No, I did not.
What was the weather like in November on around the 23rd to 30th?
I don't recall.
Well, and looking at the statement that you've just been referring to, there's some reference to it being freezing outside. You recall discussing the weather?
Objection, hearsay.
Overruled. Question initially was, what was the weather like I'll allow her to answer.
I'm sorry, what was the question again?
What the weather was like that time of year, that day, that year from November 23rd to 30th?
Based on the statement that you're referring to, I would cold.
No, God.
Now,
Oh, detective, you're slow. She's only been a cop for 7 years. Did you not hear the prosecutor object to that? It's hearsay. You're taking Jim's word for it that it was freezing in Florida in November? I mean, it's not impossible. I understand it is freezing in Florida. Nowish. Seeing the videos of the iguanas falling out of the trees and so forth. It's not like it never happens. But you're not going to just take Jim's word for it. Why on earth would you do that? Oh, she's got a lot to learn as a detective. Not real quick on the uptake, this one. I'm already suspecting this may be a rocky cross. If we do, in fact, get about 45 minutes of cross, it will by far be his longest cross in this whole case. Longer than Christy's. And if she is this easy to push around, I'm going to be able to see why.
The prosecutor asked you about the portion of Mr. Martin's statement where you asked him about what would happen to him if he didn't eat. Did you also ask him what would happen if he didn't take his medication?
I believe I did.
And do you recall what his answer was?
I believe so, yes.
And what was his answer?
Objection, hearsay.
You're on context.
Overruled.
You know what I mean with that approach?
Yes, sir.
They're going to have a self-serving hearsay conversation. Remember this? Remember this? This was the subject of much dismay in the Richard Allen trial, where the state gets to cherry pick the things that you say and present them as evidence and then object to you trying to bring in other things that you said to put them in context, because when the state offers it, it's not hearsay. It's a statement of a party opponent. It's an admission. But when you do it, it's your own statement. It doesn't fit that exception. And so the way to get that in is the rule of completeness. Any other part of the statement that in fairness should be considered to give it context. Some judges take a very narrow view of what the context is, and others will take a very broad view. And it appears this judge is going to take a very broad view. But the prosecutor doesn't want him to be able to bring out the favorable stuff from the statement, because then that alleviates the need for Jim to testify, to say the good things himself. That's what the state wants. Interesting to see how these same situations can get handled very, very differently in different courts, depending on where you are. What would happen if he didn't take his medication? He said if he didn't eat, he would get weak. He would get weak. If he's diabetic, he would get weak. Yeah, I said that's probably directionally true, because you'd be in a coma. Right. The whole problem is your ability to manage insulin levels, and not enough food means no blood sugar, and you get a little insulin spike. You're gonna have a blood sugar crash. You're going into a coma, is what's gonna happen. So yeah, that'll make you pretty weak, won't it? But it probably won't make you just peacefully hang out in a shed in the freezing cold for a week or so.
Other statements that the defendant made on cross-examination to give context, I believe was the proffered reason, is not an exception to the hearsay rule.
So they're having an argument now outside the presence of the jury. This is not something they can resolve at sidebar. Send out the jury. They're going to be arguing rule of completeness.
The state can elicit statements of the defendant because they are admitted as a party opponent, which then makes them admissible. However, the defense in cross-examination does not get the same liberty with the rules of evidence because they're not being offered by a party opponent because it is the defense attorney eliciting the statements by his client. I agree that this line of testimony would be admissible had it be coming from the defendant who was on the stand. But through this witness, it's not being offered for impeachment.
Well, that was my next question. Mr. Hancock said it was for, to put the context, and I assume that he's laying a predicate then to ask a question. So is your argument he cannot impeach a witness with a statement the witness has used by laying a proper predicate?
Well, no, I'm saying that if there's something to impeach, then that can be done. However, the question of what did my client tell you happened if he didn't take his medication, that I don't understand what that's impeaching.
Here's what you can do for me. Give me the citation to the rule of evidence that you are relying upon, and I'll allow Mr. Hancock then to respond.
Yes, if I could just have one moment.
Yes, sir.
He's right. It's not impeachment because he never asked her anything about what Jim said about medication. That would be, an inconsistent statement.
Your Honor, Florida Rule of Evidence 90.803, subparagraph 18, titled Admissions, states that a statement that is offered against a party and is, and the specific portion is, well, 803.18 is the admission against a party. And I'm looking for a statement that is offered against a party, so the party opponent, and that statement is his own statement either in an individual or representative capacity.
Yes, sir.
The portion of Earhart's that also talks about this is section 801.3 in Earhart's, which is titled Hearsay Statements by a Criminal Defendant. And Earhart states, starting in the second line in that section, or actually I'll just read the first about 5 lines of 801.3 in Earhart's.
What page are you at?
That is the 2000, I have the 2010 book in front of me, but it is the first portion of 801.3. In this book, it's at page 784. It states that when the prosecution offers an evidence, the statement of a defendant, it usually does so for one of two reasons. First, it may wish to use the statement to establish the truth of the matter stated. In these circumstances, the statement is hearsay but admissible under section 90.803, subparagraph 18, subparagraph A, the admission by a party opponent exception. This portion also does cite to section 803.18 within Earhart's.
Okay.
So that allows that the prosecution can admit the statement because it is done by a party opponent. My argument is that the question of whether or not the defendant or his responses to not taking medication, I don't understand what, I don't see what that is impeaching at this point.
You see your book. I can't find where you have a different edition.
Yes, ma'am, that's.
This is likely some kind of commentary that they rely on to discuss the rules of evidence and so forth. Similar books like that in every jurisdiction.
Your Honor, if I might, if the court would look at Hussein versus State, found in 5/7/1066, 3rd DCA 2002, square on point, and note 1 and 2. What was it? 805/7/1066.
What's the name of the case?
That is Hussein, HUSSEAIN versus State, it's the 3rd DCA.
805 Southern 2nd 1066.
Yes, Your Honor.
What year?
2002.
Go pull it up there, Judge. Maybe this is what's going to take up all our time, is this argument on asking him about his medication. At the end of the day, what, would he just get weak if he didn't take his meds? Like, may not really be a big deal. Guess we'll see. The real issue here is the prosecution wants to nip this in the bud right now. He doesn't want the defense to be able to cherry pick whatever else is there in that interview and get it in. All the ways in which Jim is a victim. Jim is so sad. Jim made excuses, et cetera, et cetera. Make him get on the stand and do it. That's what the prosecution wants.
The other side. 849, 376. 849, 376. Yes.
I'm with the state here on there's nothing that's being impeached, but I'm open to a rule of completeness argument if that's where the defense is going. Does it, in fairness, need to be considered to give the whole thing context? Perhaps. Hard to know until we know what the answer is.
I guess we can agree to disagree.
Everybody pausing to read a case here? What's the deal? He plays the pen game during the low parts of court. I do that too. I play pen games. I'm a little bit more inclined to break off the little clip part of the pen. I'm never really trying to, but I just fiddle with it and I end up busting it off. So I have tons of pens around with busted off clips.
I see the holding of the case. You're telling us both cases, both DCs and Longitude Cotton, and West Cotton different.
All right, I've read the case. Have you reviewed it, Mr. Vestia?
I have, Judge, and I have a case from another DCA that also analyzes cotton. It analyzes cotton differently than the third district did.
And I disagree with that, Judge. In the case,
Well, can I provide the case first?
Yes.
Thank you, Judge. It's Austin, AUSTIN v. State.
Hold 1 second.
We're going to sit here while the judge reads
849
cases.
Southern 2nd, 376.
Go ahead and read that one now, Judge.
First District Court of Appeals, 2003.
Let everyone read them and then argue them. And in the meantime, just play with your pens. Oh gosh, his conference phone up there on the desk, that takes me back. I remember that phone. It's like a triangle shaped thing. Haven't seen that in a long time. Used to have those in the old courthouse where I would practice for your call into court, your telecourt. Of course, that wasn't super common pre-COVID, but it did happen from time to time. More often what would happen is just the phone would ring in the middle of the courtroom, like while you're doing something intense, like trial.
Repeat this out again, 849 Southern Second 376.
Yes, just one. 849 Southern Second 376, Austin versus State.
I apologize. Repeat that again. 849 Southern Second.
376.
It's taken him all day just to find the case.
Must be me.
Oh my gosh, listening to him pecking away up there on the keys. No wonder.
Okay, thanks.
Pause and read that one. Yes, guy in the courtroom is stretching.
Okay, I read that. I'm reading Cotton v. State.
Yes, Judge.
Look how we're in this position where court TV back in 2011 isn't even tempted to go zoom in on the laptop screen to see what it is that they're looking at there at their counsel table. What discipline? What propriety? He's in Westlaw. Tell from here. You kind of judge a lawyer by are they Westlaw or are they Lexis? If you're cheap, you use Lexis. If you want to actually like be able to know what you're doing and get the right law and stuff, you use Westlaw. Now playing the thumb game in place of the pen game. Pen game is only entertaining for so long, but that's I can entertain myself for hours with the pen. I can play pen games for quite a while. I guess the judge is a better typer than we thought, unless that's the prosecutor.
All right. I read the appropriate portions of Cotton, which is at 7637 2nd 437, Florida 4th District Court of Appeal 2000. Primary judge is Judge Taylor. And I read the 2012 version of Earhart on Evidence, specifically Section 803 and the footnotes therein, specifically focusing on footnote 5 at page 802 and 803. I'll allow it overrule the objection.
May I approach the floor?
Yes, sir.
Thank you.
So he's not going to explain why this is okay. Exactly how is this okay? Is this okay as rule of completeness? Is this okay because it's impeachment? Don't know. So they're going to be able to let Jim testify through his prior interview,
All right, to the jury.
and then he won't have to get on the stand. So as long as he said good things in that interview, he doesn't need to change. He's catching a break here. That said, it sure doesn't sound like the interview
Please
is
recognize the
really
presence of the jury.
consistent with self-defense.
Sir, you may inquire.
Thank you.
I will overrule the objection.
Thank you, Judge. Detective Evans, you can answer the question, but to restate it so I refresh your memory. Do you recall what Mr. Martin told you would happen if he didn't take his medications?
I don't recall word for word, but
Would it
Yes.
refresh your recollection if you looked at the transcript?
yes, it would.
Part 1, page 23, line 24.
Get weak, pass out, go into a coma.
Does that refresh your recollection?
Yes, it does.
And what did he tell you would happen if he didn't take his medication?
A coma and you just pass out.
And the prosecutor was asking you about the section in your interview, which ran from like page 73 through 76, about Mr. Martin going to Daytona to see if he could find Christy, correct? You talked to him about that?
That's correct.
And did he give you a reason why he would go over there and check on her?
Check
He
on
wanted
her.
to see if she was gonna meet up with Sherry or if she was gonna be doing something else.
And do you recall what that something else was?
Objection relevant.
Sir,
It's it's totally relevant to explaining his actions on that particular day.
sir.
This is mentioning a prior bad act.
Judge, may we approach?
Please.
A prior bad act. Or something else. Wonder what the prior bad act is. Is she going to go get cocaine? That's going to be his excuse, maybe? Totally wasn't stalking her, calling her up and threatening her the way that both Sherry and she described independently. It was for her well-being, I'm sure. I'm sure it was. That's the only prior bad act we've heard about so far is the cocaine use. So that's why that's my guess. To make sure she wasn't going to go.
Wait. All right.
He had other reasons for going over there?
Objection, Your Honor.
Overruled. You can answer that yes or no.
Yes.
And you were also talking with the prosecutor about the section about talking with Mr. Brasher when Mr. Martin called Mr. Brasher and Mr. Martin had been talking to Mr. Selkirk. And you were aware that, or became aware that the police came out to make sure Mr. Martin was okay at some point that day, correct?
That's correct.
Now, we have talked about a transcript of the conversations you had with Mr. Martin. Did you also tape record your conversations with Christy Martin?
Yes, I did.
What happens after you bring the tape recordings back to your office?
Usually I place them on a CD, I put them with my file and request transcripts.
In a case such as this that goes over to the state attorney's office, do they often get transcribed?
Most often, yes.
And that's what happened with Ms. Martin's conversation that you and the prosecutor and I have just been talking about, correct?
Yes,
Did that also occur with the conversations you had with Ms. Martin?
yes, it did.
Your Honor, may I approach the clerk?
Yes.
Detective, I'm going to show you what's been marked as defense exhibits U, V, W, and X, and ask you if you recognize those.
Yes, I do.
And can you tell the jury what those are?
Transcripts of my interviews with Christy Martin.
Now, did your office transcribe those?
Yes, I believe it did.
And are they an accurate transcription of what could be heard on those tapes?
I believe so, yes.
I want to call your attention to the conversation you had with Ms. Martin on November 23rd. During that conversation, did she tell you that she tried to shoot Mr. Martin?
I don't recall without looking. If you have
If you
specific.
would look at transcript, I believe it's V, it's part 3 of your conversation with her,
Okay.
page 3, line 15. Does that refresh your recollection?
Yes, it does.
And did she tell you that she had tried to shoot Mr. Martin?
Yes, she did.
And that was on the 23rd.
That's correct.
Also on the 23rd, do you recall her saying that Mr. Martin had never been physical with her before?
Yes, I do.
Also on the 23rd, do you remember her saying that Mr. Martin got the gun from under the bed?
I don't recall that specifically.
If you would look at what's been marked part 2, which is exhibit V, page 2, line 19.
Which part was that?
Part 2.
So page 19.
No, page 2, line 19. Does that refresh your recollection?
Yes, it does.
And did she in fact tell you that he got the gun from under the bed?
Yes, she did.
Did she tell you that the guns, both guns were normally kept under the mattress on her side of the bed?
I don't recall that specifically on her side of the
Well,
bed.
okay, I'm sorry. She said under the mattress, correct?
On both of them?
Yes.
I don't recall on both of them.
Specifically the pink 9mm?
Yes.
Then you went back on the 24th and interviewed her at ORMC, correct?
Yes, I did.
And if you would look at Defense Exhibit X, that's a transcript of that conversation?
Yes, it is.
Oh, let me go back to the 23rd. Did she ask you if Mr. Martin was dead?
Yes, she did.
Okay, let's go to the 24th then. Did she tell you on the 24th that she got the gun out of Mr. Martin's pocket and pointed it at him?
All the way out of his pocket? No, she did not.
Okay, if you would look at page 30, line 15. Do you recall that question answer now?
Yes, I do.
And did she tell you that she had actually gotten the gun out of his pocket?
Yes, she did.
And did she say she pointed that gun at him?
Yes, she did.
And Did she also say that again later, if you look at page 32, line 9? Did she say that I actually got the gun out of his pocket?
Yes, she did.
And did she also tell you that there was a struggle over the gun?
Yes, she did.
Nothing further going.
Redirect.
Yes, please.
Not
And
actually
you
a
still have
warrant
those
process.
exhibits in front of you?
Yes, I do.
Okay. I'd like to direct your attention to the third part of the interview.
I'm just going to pause here. It was a shorter cross than I expected, just given the time that it looks like we're working with here. I can't help but notice that the defense has put all of Christy's interview transcripts into evidence, and the state did not do the same with Jim's interview transcript. And it seems like they could, right? If the defense can do it, why can't the state? It is Jim's statement. And so theoretically, the whole thing is admissible. I don't know if that is a good call or a bad call. You know, if they don't want the unselected statements coming in, then I guess they're doing that on purpose. They're not offering the whole thing because they don't want the jury to have it back there in the jury room and sit and read the entire interview and see all the things the state is not presenting them. But I have to wonder if they're going to notice the discrepancy. We have all of these, but we don't have this other one. We only have just the bits and pieces of what we were told through Detective Evans's testimony. And is that going to be is that going to make it look like the state's trying to hide something? Is it going to matter? I don't know. I just can't help but notice there is a difference with how those transcripts are being treated.
You were asked about page 3, line 15, the question of whether or not Ms. Martin, the day of the incident, while she was still in the emergency room at the hospital, stated that she tried to shoot the defendant. You remember those questions on cross?
Yes.
During that interview in the emergency room the day of this incident, Ms. Martin told you, I tried to shoot him, but I was too scared of him, pointing a gun at him. Is that what she said to you?
Yes, it is.
I don't have any other questions of the witness.
Recross as to that one question.
Do you recall in your conversations with Ms. Martin or with Mr. Martin what his reaction was when Ms. Martin pointed the gun at him?
Without looking, no, I do not.
Do you remember ever asking those questions about that situation? How did Mr. Martin react when Christy pointed the gun at him?
I remember speaking of that, but I don't know specifically. I guess I'm not really understanding what you're asking.
Well, the prosecutor specifically said, or has asked you about a response she made, that she pulled the gun out, pointed it at him, but was too scared to fire the gun. Did you ever do any follow-up to see what reactions there were to that?
As far as the defendant,
Yes.
he did mention that in his statement, yes.
And what happened?
He said that he had walked out of the room. I don't know specifically what else he said,
And
but
did he also talk about struggling over the gun?
yes, he did.
Nothing further done.
All right, will the witness be excused from her subpoena?
Yes, sir.
Sir? Do you understand that means she's excused from the jurisdiction of the court?
Yes, sir.
Yes.
You are free to go. Return those to the lawyer and return them to the clerk.
Your Honor, Mayor and I have a moment.
Yes. Lawyer?
Contrary.
They getting ready to rest?
Thank you, ma'am.
Hard to tell. Have
Your
a
Honor, at this time, the
moment.
state of Florida rests.
State
That
rest.
means you call no other witnesses?
That is correct at this time.
Do you have any other evidence to introduce at this point?
Not at this point.
Members of the jury, step out for just a moment. Please leave your pads and pens in the chair.
All right, for the jury.
Not really the best note to leave it on. Didn't contextualize that part of the conversation or anything. Didn't give the jury anything more. Just heard Jim did, in fact.
All right, the jury's out, doors are closed. The state of the rest of the defense, you may proceed.
Judge, this kind of, the defense was making a motion for judgment of acquittal. I think that based on the facts that are before this case, that a reasonable jury could not return a verdict of guilty, and that the court should direct a verdict at this particular time.
Pro forma will lose.
Mr. Garcia?
Yes, Judge, would the court like me to argue why we, or how we've established a prima facie showing of each 3 counts since the motion's just been made generally?
Well, sir.
Why don't I? The defendant's charged in 3-count information with count 1, attempted first-degree murder with a firearm, and in count 2, attempted first-degree murder with a weapon. That weapon has been alleged in the information to be a knife. Judge, in looking at the 3 elements to establish attempted first-degree murder in a light most favorable to the state and with all reasonable inferences of the evidence drawn towards the state.
Yep.
In count 1, the state must show that James Martin did some act intending to cause the death of Christy Martin that went beyond just thinking or talking about it. As it relates to count 1, in a light most favorable to the state, the testimony has been that the defendant purposefully stood in front of the victim, discharged a 9mm that was in his possession. We know that the day of this incident, Christy Martin was shot by the pink 9mm. That's in the evidence of states 87 due to the forensics involved. In addition, we know that in a light most favorable to the state, that evidence of her testimony is supported by the fact that the defendant's blood is found on the grip of the firearm. Coupled with the victim's testimony that she was shot in and of itself, we believe establishes a prima facie showing that the defendant committed the act of shooting, in addition to the other items that I've talked about. In count 2, the light most favorable to the state through the victim's testimony was that the defendant used a knife that she has identified and has been received into evidence, that she was stabbed more than once in the chest, and was also cut severely in the leg. The court has heard the testimony about that. So we believe that we've established a prima facie showing in element number 1. Element number 2, the state must show that James Martin acted with a premeditated design to kill Christy Martin. I'd like to talk about the premeditation collectively, Your Honor. First of all, the light most favorable to the state, the evidence has established at this point that the defendant used multiple deadly weapons in a manner likely to cause death through shooting an individual, Ms. Martin, in the chest. I'd like to talk about the knife first, since the testimony is that the victim was stabbed in the chest for a few times before. The victim has testified that she was stabbed 4 times in the chest. To stab someone in the chest repeatedly does show intent to kill, we believe, just the act in and of itself. When we get to the gun, after having stabbed someone multiple times in the chest, deciding to take a gun and shoot them in the chest also establishes, we believe, an intent to kill. In addition to the act itself, Your Honor, we have all the testimony that leads up of the 5 days. The 5 days worth of lead up to this shows, we believe, in a light most favorable to the state, that the defendant was confronted with the fact that his marriage was over and his wife was leaving him with another woman. The defendant attempted to control and manipulate the situation first by talking and arguing with the victim when she still proceeded to go and meet up with Sherry Lusk, somebody that the defendant knew about the entire 20 years and brought up in conversations repeatedly. The defendant escalated his attempt to control her by sending text messages, by actually stalking her to another county, by telling the victim that he was so close that he could touch her at any time. When the attempts to control the victim that way, to stay out of the situation with Ms. Lusk, were unsuccessful, he attempted to blackmail her through the use of the video, the stills of the video that he sent to the victim. When that had no effect on her, he then started to reach out to common friends and other people in an attempt to control and blackmail the victim on the day of the incident. And the court has heard the testimony from Mr. Late and Mr. Brasher to that effect. And when the defendant's control to further manipulate the victim still didn't work at that point, the testimony is that the defendant was in front of 2 loaded guns, as he told to Mr. Brasher that he was in a bad way 4 hours before the incident.
We believe, Judge, that the evidence in this case establishes that the defendant lost control. He's admitted to Detective Evans that he could have killed her that day, and that when the defendant lost control, the only way that he could control Christy was to kill her, and that's what he attempted to do. We believe that this has been established beyond a reasonable doubt, but that's not even the standard at this point. The standard is a prima facie showing, the lowest evidentiary standard in law, and we believe that we've reached that as to premeditation. In count 3, the state must show that the act would have resulted in the death of Christy Martin, except that someone prevented James Martin from killing Christy Martin, or he failed to do so. Actually, Judge, we believe that there's evidence of both. First of all, the defendant failed to do so. The defendant didn't complete the job that he intended to do that day. Ms. Martin was stabbed, repeatedly shot, left for dead in her bedroom. The person that prevented James Martin from killing Christy Martin that day was Christy Martin. Ms. Martin testified that she was able to drag herself out of the will, summon strength. She testified from the Lord, and I'm not here to have a church discussion, but Christy Martin presented herself from dying in that bedroom that day. We believe that the evidence does show and has sufficed for premeditated attempted murder with the firearm, with the knife independently, and would ask the court to deny the judgment of acquittal as to count 1 and 2. In count 3, the state must prove 3 items. First, that James Martin intentionally touched or struck Christy Martin against her will or intentionally caused bodily harm. We believe that the evidence is clear, as I've already alluded to in count 1 and 2's argument. That in number 2, James Martin, in committing the battery intentionally or knowingly caused great bodily harm, permanent disability, or permanent disfigurement. The court heard the medical testimony that the left lung was completely collapsed, required the use of multiple chest tubes, that the injuries were severe enough to where Ms. Martin had to be transferred from one hospital to another, where she stayed for over a week. I would argue to the court that even the wound of the calf being butterflied in half down to the bone in and of itself was great bodily harm. In and of itself caused disfigurement due to the scar. And the court is well aware that scarring is one of the factors to be utilized in disfigurement. In addition, the need for a week of hospital stay, of multiple chest tubes, of 3 units of blood clearly establishes the existence of the great bodily harm. And as I've argued in count 1 and 2, that the intentional acts of stabbing in the chest and shooting in the chest evidence great bodily harm. The last item that we must prove for count 3 is charge that the defendant utilized the weapon, and I've already argued that. So judges, state of Florida's position that we've established a prima facie showing on all 3 counts as charged, and would ask you to deny the motion at this time.
Your Honor, brief rebuttal, if I may. The evidence in this case indicates that worst case scenario that Mr. Martin was in a bad way and possibly a danger to himself. This was evidenced by the concern by Mr. Brasher, who called the police to go and check on him, by the police going out and checking on him, and by Mr. Selkirks basically saying the same thing. The state's belief that he merely lost control once Ms. Martin returned home would not support a finding of premeditation, and at best this should be, or at worst case scenario for my client, should be acquitted down to either attempted second or attempted manslaughter. However, I think to allow the jury to make a decision as to counts 1 and 2 specifically would be to ignore the cross-examination testimony of both Detective Evans and Ms. Martin herself, in which there is evidence of a struggle, evidence of aggression on Ms. Martin's part, and that merely because she comes in and testifies at one point today, or on Tuesday, that Ms. Martin was trying to kill her is not sufficient to overcome all of the evidence that would be most favorable to the state. And I would ask for JOA on counts 1 and 2 specifically. Counts 3, again, the testimony all seems to be this was a struggle and not an intentional act on Mr. Martin's part.
No, it doesn't.
Gentlemen, what is the standard of proof at this stage when the state rests and
Prima
Yes.
facie. Whoa.
for a motion to, what's the standard as you understand it? First, Mr. Hancock?
The standard at this point in time, Judge, is the evidence in the most favorable light to the state. That doesn't mean we ignore all the evidence and just look at particular parts, is my argument.
The standard is a prima facie showing. That prima facie showing must be based upon all of the evidence individually and as a whole, taken in a light most favorable to the state, meaning that the state of Florida receives every reasonable inference from the evidence individually and as a whole.
And credibility
to establish the prima facie showing.
goes in favor of the state. So to the extent you're saying doesn't count because she's not credible, doesn't factor in at this stage. Surely this judge knows this. I'm sure he already knows that.
If you look at the information, there's certain things that are common to all three counts. We have the testimony of Dr. Brent Gardner, who first saw Christy Martin in the pocket of the hospital. He says her injuries were life-threatening to the extent that she was medevaced or airlifted from Apopka Hospital North to Orlando Regional Medical Center, which is a trauma center, the only trauma center in Central Florida. Because of her collapsed lung, surgery that was required, they didn't have a surgical suite in Apopka, and therefore she was transferred to Orlando Regional Medical Center. We have the testimony of Rick Cole, who picked her up, indicating her injuries, that she was covered in blood. Her testimony to him, or his statements to him as to what happened and how she was injured. His observation of her calf in the hospital, which he said was laid open like a piece of meat. Then we have the testimony of the Christy Martin herself about her injuries and how they occurred, how she was hit, she thought punched, and then she realized she had been stabbed on at least 4 occasions. The photographs show the injuries to her breast, side, calf, and other parts of her body. There was testimony concerning the injuries to her head, specifically behind her ear, her right ear, and obviously the photographs of her with the evacuation tubes in her lung so that she would not lose the ability to breathe and impair the functioning of her heart and lungs. We have the testimony of Alina K. Burrows that a firearm was used. Initially, someone said it was a Taurus, then someone called it a Glock, and then we know it's a Taurus 9mm, pink in color. It's a functioning firearm able to discharge by the effect of an explosive. We have the testimony of a deputy who saw her in the hospital and took statements from her to determine the place of the crime and the person she stated committed the crime, which was in Apopka, Orange County, Florida. We have the testimony of a sergeant with the Orange County Sheriff's Office that they set up a perimeter, did not know if the house was occupied or not occupied, or if there were other deceased people in the home, or deceased people in the home. They entered through the back entryway, specifically on the patio. They looked through the window first. They saw blood in every window where they could look, specifically in the bedroom. When they entered the home, they saw blood in the patio, on the family room area, all the bedrooms, the bathroom, along with bloody clothing, towel. That was examined, and we have the DNA testimony that the blood belonged to 2 people, James V. Martin and Christy Martin, and that certain items were Christy Martin blood was the only blood sample he could find on it, and some Mr. Martin. Others, there was joint blood. We have the testimony of the K-9 officer who testified that he apprehended Mr. Martin at the time. He had a knife in his right hand, was given verbal command to drop the knife on several occasions, and when he did not, he drew his service weapon and told him he would shoot him if he did not drop the weapon. Eventually, he did drop the weapon. He was taken into custody, transported to the hospital, where he was interviewed by an Orange County detective who testified as to statements Tara Evans that she received from Mr. Martin. Most telling were the statements he made that he never cut or shot Christy Martin. Taking light in the evidence most favorable to the state, the prima facie case has been proved. Motion is denied. You
Yep.
need a few moments, gentlemen.
Yes, please, Judge.
Let's take a short break. Let's come back at 10 after 11.
Knew that motion was going to be denied. That's it for today, huh? Yeah. Well, state rested. State rested. That was it. Not necessarily finishing on your strongest foot. I was not super impressed with Tara Evans. He didn't say how long she'd been a detective. It sounded like she said she'd been a sworn law enforcement officer for 7 years. So not very long. A maid detective real quick. This event happened about a year before already. How long had she been a detective? Not really the brightest bulb. Doesn't remember a whole lot of stuff. Really did her best during that first part of the direct to give all of the reasons why it was hard to get information from Christy, and she was having a hard time answering and having a hard time remembering, and she was in a lot of pain, having a hard time giving information because of her state. But at the end of the day, had to get the interview done because she was in a critical condition and needed to know what she could tell them about what had happened so that they could do their investigation. Didn't really add anything from her own observations as far as the house and the blood spatter and stuff like that we already know about. But then we got to Jim's interview. Yeah, we knew that this happened. We knew he did. Didn't ask to substantiate that part about going in to take a shower. Told somebody he went in to take a shower. Well, it was her. So twice he went into the house. He crawled in one time to get a roll of bread. Please, sir, may I have some bread? Oh, gosh, don't you just feel for this poor little waif, this little street urchin? It's like, it is, isn't it? It's like he's trying to imagine a Dickensian kind of grave misfortune. And how would you describe it? Well, surviving for a week on mere bread is kind of how you would expect Dickens to describe it, wouldn't you? He spent a week in that shed, 7 days behind Scott Selkirk's house. And he said he had passed out lying there, but he was able to crawl to the residence to get food. But mainly he just laid there and waited for someone to find him. So he could crawl to the residence to get food. When did he wake up out of his coma and then get food and then go back in his coma? Why didn't he just stay in the damn house if he's trying to be found? This is so ridiculous. So ridiculous. He just laid there and waited for someone to find him after putting himself in a position where you just stay there, you'll be found. Because the Selkirks will come home at some point, won't they? And then you don't have to crawl back for another roll. And please, sir, may I have another? God. Oh, my sympathy is below. You could dig all the way down, come out in China on the other side, and still not have reached the point at where my sympathy for Jim Martin resides. He's diabetic, takes multiple pills. Didn't say anything about insulin injection, but maybe he takes oral insulin. If he didn't eat, he would lose his strength. Yes, I'm sure he would. He would go into a freaking coma. And then what's going to wake you up? What's going to wake you up from that coma? Luck? Luck might do it, but otherwise, sugar. And I don't see how you are going to pull that off somehow, regaining consciousness and getting a role. It's just, this is pretty silly. Describe that 24/7 togetherness in the relationship. It just sounds so oppressive to me. So oppressive. Just never being able to have your own space. And you almost like, I think he thinks that makes it sound like romantic and dedicated or something. You know, he just couldn't be without her, but it doesn't. It sounds like a freaking dependent infant clinging to you all the time. Wails as soon as you try to pay attention to anything else. It just sounds exhausting. And it just so puts into perspective to me that that just fatigue that Christy showed on the stand anytime she had to talk about this relationship, that weight that sat on her. Oh, it just wore her absolutely out, and I can so get it. So he brought up Sherry. He just didn't want to see her. He was just hurt. That's the only reason he stalked her. The only reason he stalked her is because he was hurt. Yeah, his ego was hurt because she wasn't doing what he wanted. She wasn't putting his needs before hers anymore. That's really what it was about. She wasn't putting Jim first. She was done. He was hurt. So he stalked her and blackmailed her and so forth. But no, according to him, he just, I don't know. Just wanted to see where she was going. Doesn't sound good. That is an admission to stalking. Admitted having conversations with her, but, sort of denied and texting back and forth. And he admitted the blackmail. It'd be real nice if these pictures hit the market. He admitted saying that. Oh. Admitted that he blackmailed her. Told Scott Selkirk he didn't think he could live without her. Don't think I can live without her. Shared similar thoughts with Bruce Brasher, according to him. Well, Bruce Brasher's version we looked at, sitting there with 2 guns in a bad place. And would you like this porn of Christy? I'd like to send you. No, Bruce Brasher didn't want it. Does that sound like a hurt guy, or does that sound like an angry guy? And at the end of the day, the judge said the most important thing, and I agree, he just denied it. He denied it all. They always do. They deny it, and then when denying doesn't work because you're caught red-handed, then they start looking for an excuse. He didn't come out and say, yeah, I'm so glad you found me because I was terrified this whole time because Christy tried to kill me and I had to defend myself. Never once during this interview said anything like that. Just flat out denied it. No, I didn't stab her. I didn't shoot her. Must have been somebody else. And he said, I could have killed her. The gun was right there beside her. Yeah, I could have. So you were thinking about it. Interview that we heard on direct was certainly not particularly helpful to Jim, but then the defense on cross was able to get out some additional details after that long sidebar. The judge didn't give us a real good reason why he was finding a hearsay exception here. But at the end of the day, don't know that it really matters. If Jim didn't take his medications, he'd go into a coma and pass out. So then how did he wake up and crawl into the house for his piece of bread? Was it freezing outside? Why does this matter? If it was freezing outside, doesn't that make it like less reasonable to hide out in a shed for 7 days? It's freezing. You really didn't want to be found. You really didn't want to be found. You sat out there in that frozen ass shed, no heat, no insulation, just a dinky little shed. You really didn't want anybody to know you were back there. I wish we could have heard from the first canine, because I'd like to know how they flushed him. How'd they flush him out of that shed? The first canine was back there with the dog and found something. And then the second canine is who we heard from, and he went out ahead. And they ended up at the 849 Thompson in the abandoned lot. I would have liked to have known, how did they flush him? What was he doing? Did he hear them coming? Was he out taking a leak? I mean, what? I don't know. Don't know that we'll get to find that out. Seems unlikely, since I doubt Jim is going to tell us. But we'll see. Had other reasons for going to Daytona. Didn't get to elicit that. But no, he totally wasn't just stalking her. He had a totally legitimate reason that they're not allowed to get into. How do you think the jury is going to take that? Totally legitimate other reasons that have something to do with a prior bad act. And then concluded with those statements from Christy's interview that he has relied on so heavily, that she tried to shoot him. He'd never been physical with her before. Jim got the gun from under the bed, and that both guns, or at least a 9mm, were normally kept under the mattress. She asked if Jim was dead. And at some point she said she got the gun out of his pocket and pointed it at him. And there was a struggle over the gun. Very important points to the defense. It's just that they're not real helpful when they stand in contradiction with what your client has said about denying that he did anything wrong. He didn't volunteer an explanation for how there was a struggle and she was pointing a gun at him, and he had to respond to the threat. He just flat out denied it. So not necessarily the strongest conclusion. On redirect, the state gets that she said she tried to shoot him but was too scared of him, pointing a gun at him. We never did get an explanation for that second shot, did we? Not in the state's case. Not in the state's case, we didn't. And then on recross, Jim mentioned in his statement that he also talked about this. So we don't have context. We don't know, is this something that he brought up out of the blue and it corresponded with Christy's statement about there being a struggle and he pointed a gun, she pointed a gun at him, and then he walked out of the room? That was his explanation. Or, because that would tend to imply that's what happened, right? If they both come up with it independently and it matches. But if the detective told him that Christy had said that and then he just adopts it, it's a little bit of a different situation, right? Now it's just opportunistic that sounds like it benefits you, so we'll go ahead and go with that. We don't know. They didn't flesh out any of that context. So that's really the last thing that we heard, is just this kind of emphasis on the version of events where Christy has pointed the gun at Jim and is kind of threatening to shoot him, and they've struggled over it. And Jim just walks out of the room. Don't know that it supports self-defense, but isn't necessarily the powerful, vindicating finish you normally want to end your case on. So the state rested with the conclusion of Detective Evans, and then we had the motion for judgment of acquittal. Yeah. Pro forma, everybody knew that wasn't getting granted. And, even the defense lawyer arguing it knows it's not getting granted, because if you have to argue, consider the cross, you're just basically saying, cherry pick the things that benefit me. And that's literally the opposite of the standard. The standard is cherry pick the things that benefit the state. And so we ended up with this rather long list of evidence that, according to the judge, constituted the prima facie case. The injuries were life-threatening. She made statements to Rick Cole about how they were inflicted. He saw her calf. Christy's testimony herself was that she thought at first she was hit or punched and then realized she'd been stabbed multiple times. There were photos that showed her injuries. The firearm was used. The deputy Fernandez, who spoke to her at the hospital, was able to determine the place and the person that Christy said did it. Sergeant Callahan saw blood at the house. They got the DNA results from that, both Jim and Christy's blood. The canine who tracked Jim found him with a knife in his hand, which, by the way, he didn't immediately drop. They had to point a gun at him to get him to drop that knife. Not particularly good evidence. And then the interview at the hospital where he gave statements, which the most significant ones to the judge, he never cut or shot Christy. You think this judge has seen some domestic abusers before? Think the judge knows how deep the denial runs? I kind of bet he does. Kind of bet he's seen this a few times. So the motion is denied, and that means when we come back, we have a defense case. We have a defense case. See what it is. This point, if they're going to establish self-defense, Jim has got to testify, period. He has to. Is he going to have the balls to? I'm skeptical. I'm very skeptical. Because he knows, you can see this is the first time that we have seen him just look at the jury over and over and over, just like pleading with his eyes, looking at the jury. Please, are you believing this? Please feel bad for me. Didn't you see? I only had a roll for the whole week. I was so hurt. Don't you feel bad for me? Nobody feels bad for you when you shoot and frickin' stab the person you are supposed to love and cherish. Nobody feels bad for you. Kind of feel like the judge has maybe seen this a few million times, like everybody else in the criminal justice system. So, guys, when we come back, onto the defense. What do they have? What do they have? They promised us self-defense in opening. They told us credibility was critical. So we already know, okay, there's inconsistencies, but do they add up to self-defense? They haven't done that so far. Why? Because your client talked to the police and denied everything, didn't make a self-defense claim. So he's going to have to explain that. He's going to have to explain it. It's not that like legally you have to testify in order to present self-defense. It's something that can be inferred from the circumstances. You have to be able to make an argument from the evidence that you were placed in reasonable fear, that your life was in danger, and that you used reasonable and proportionate force in response to that threat. And so there's no rule that says you yourself have to get on the stand and say I was afraid. It's just like in mental state for every other type of crime. You just infer it from the circumstances, from what you did and what the actions were. I had a case. There's like always a case. I had a case that went up on appeal. It was a case I won because the defendant was denied a self-defense instruction because he didn't testify. And there were multiple witnesses to this event. This took place in jail. It was a jail fight. And we had multiple descriptions of what happened and how, the guy was calling out my client and what went down and so forth. And the judge said he didn't testify, that he was afraid, therefore no self-defense. I won that on appeal. He doesn't have to testify. You can infer it from circumstantial evidence. So it's not like that's the rule. It's just that it's not obvious from these facts that that's what happened. And so seems kind of like you're going to need to explain what the sequence of events was, for example. What justified you in stabbing Christy 4 times and shooting her? Like, how was that proportionate? What did she do to present a threat that required that kind of response? You're going to have to get up on the stand and explain that. And I don't think he's going to have the balls to do it. I don't. He already knows. Look at him looking at the jury. Please, please, but I need you to roll. It's got nothing but manipulation and feel bad for me. And the prosecutor isn't going to feel bad for him. And he already knows that. And so he knows. Denial didn't work. You think explanation's going to work? No, I don't think he thinks he's got an explanation. So we'll see. Looking forward to what is the defense going to have here to try to mitigate what seems to be a pretty solid case that, yeah, he stabbed her and shot her, left her to die. She was lucky enough to get away and got treatment. And then he ran and hid for 7 days until a dog tracked him down and he nearly got shot, not wanting to drop his knife once they arrested him. And then they talked to him at the hospital and he denies doing anything wrong. We never did get digital forensics. Never got the text messages. Never got that laptop that was in the bottom of the pool. Just kind of there as an aside. I don't know. We'll see if anything comes out of this in the defense case. So, guys, yeah, when we come back next time, see what they got. So, enjoyed getting to the end of the state's case here. And now we move on to the next phase, guys. I'll see you next time.